The High Court in Johannesburg has declared as unlawful the action of seizing Bosasa assets. The judge also ruled that sales of the company's assets before the second meeting of creditors was prohibited. Written consent and a resolution of the Board of Directors of African Global Holdings or the consent of the court would be needed before any such move. Lawyer Ulrich Roux is a founder and managing director of Ulrich Roux and Associates. He joins us now via Skype. A very good evening to you, Mr. Roux, and thank you so much for speaking to us. So it was dubbed the auction of the decade. So where did it all go wrong?
Yes, well, more than 100 million rands worth of goods were sold at that auction, and the High Court today ruled that the auction should never have taken place and that the liquidators were not within their rights to proceed with the auction as the liquidation process had not been finalized as yet. So unfortunately, the sale of all of those assets now being deemed as having taken place unlawfully so.
But I'm just trying to understand, how can people go ahead with the auction and sale of these assets immovable as well if there is no acquiescence, if there is no authority given to do so?
Well, remember that the Bosasa companies had been liquidated or were in the process of being liquidated, but a final liquidation order had not been handed down yet, and that is what the court ruled today in essence, in a very lengthy judgment, that the provisional liquidators acted too soon, that the final liquidation order had not been granted as yet, and that they had no right to proceed with the sale of the assets, that the liquidation process still needed to be finalized, and up until that process is finalized, the sale of the assets could not have taken place. So certainly the parties who purchased the assets now left with in a spot of bother in that they actually did not purchase it lawfully, and they would have to institute action against the auctioneers in order to recover the funds paid for those assets.
So the judge ruled that a business rescue application suspends the process of the realization of assets after the application took place, or rather of the company of liquidation. So just explain that process to us. That's what I'm just trying to understand from a layman's perspective. It's almost as if somebody moves into your house and removes your assets and sells them.
Yes, so the business rescue proceedings were instituted, which places the liquidation proceedings on hold. So in other words, the function of a business rescue practitioner is to attempt to save the company from the liquidation process and from the company being liquidated, the assets being dispersed with, and the company being finally wound up. And that is exactly what the judge found in his judgment, that was that business rescue practice had not been finalized yet. The final business rescue report had not been furnished yet, which would have allowed the liquidators to proceed with their liquidation. They were not within their rights to proceed in doing so. So only upon the finalization of the business rescue process and a final business rescue report being furnished, which confirmed that there is no way in which the company could be saved and rescued as such, could the liquidators have proceeded with the auction of the sale of the assets. And because that had not taken place, the judge found that the sale was unlawful and should never have taken place.
And in fact, the judge seemed to find that they never sought any consent. Would they then be found guilty of something, or is this something that the judge would consider as disquieting?
No, so they would have a civil claim for damages, because obviously the parties who purchased the items which were on sale at the auction now effectively need to return those assets because the sale was never a lawful one. So they would have a delictual claim for damages against the provisional liquidator. I do foresee trouble in that process because, you know, the funds that had been received have most possibly been used for other purposes, most possibly have been paid out to parties who were owed money by the Bosasa companies. If that is the case, then it's a problem that the liquidator is going to be faced with in coming up with those funds in order to reimburse the parties who purchased those assets. But not a criminal charge as such, as you refer to, more a delictual claim for damages, and it would be the damages suffered by the parties as a result of them being placed under misrepresentation that they were able to purchase these assets when in fact they were not in a position to do so, and the liquidator was never in a position to sell those assets to the purchasers.
Thank you so much for speaking to us, Ulrich Roux, who is a lawyer, founder, managing director of Ulrich Roux and Associates.